Hey everyone, my name is Heather Parker and I'm here today to talk to you a little bit about Amnesty International's proposed policy about sex work and decriminalization of sex work. I apologize in advance. I have two Bengals, there's one of them, who are going to be kind of in the background right now because I've got some work going on in my apartment. A little bit of background about me. I'm actually an international human rights attorney. I work in the District of Columbia. I'm a longtime member of Amnesty International USA. I was a longtime volunteer leader there in many different roles, and I'm actually a former staff member with the organization. Currently, I work for a state-based healthcare exchange, helping all individuals gain access to healthcare, including sex workers who are often denied access to healthcare based on the fact that their labor is criminalized. And I also sit on the board of HIPS DC. That's why you're going to see me wearing this lovely shirt here. HIPS is an organization that is a sex worker rights organization. They're also a harm reduction organization. It's kind of one of the reasons that this policy is really important to me. What I'd really like to do in this hopefully short video is to actually read out the policy for people. You've probably heard a lot about this policy in the news. There have been multiple open letters, and apparently open letters are alive and well. There have also been a lot of op-eds, there have been a lot of articles, but there hasn't been a ton of factual information about the actual policy itself in that article. So what I'd like to do today is to actually read the policy for you, and I'll also provide a link to the policy later in case you're not someone who learns, auditory ways. But I want to get that information out there because I think people, once they actually hear what the policy actually stands for, might be making better decisions about the policy. So let's go ahead and just get started. So this is the actual policy, or actually more than the policy. It is the 32nd International Council Meeting, Circular Number 18, Draft Policy on Sex Work. So you've probably seen it leaked out there on the internet. Oops. So you can find it yourself, but I'll also make sure to give you a link. But like I said, I just kind of want to go ahead and read it out for people because there's a lot of stuff in there. I'm going to skip over what the board recommended. There was a resolution that the board put forward asking for this policy to be developed. I'm not skipping over it because I don't think it's important. I'm just skipping it because the policy is actually what's really important at this point. So why don't we just go ahead and get started on that. It's fairly short, actually, just a few pages. So the official title of this policy is the Draft Policy on State Obligations to Respect, Protect, and Fulfill the Human Rights of Sex Workers. Great name for a policy, fantastic name for a policy. So the introduction for this policy is that this policy has been developed in recognition of the high rates of human rights abuses and violations that sex workers experience globally. This document identifies the most prominent barriers to the realization of sex workers' rights and underlines state obligations to address them. This policy should not be considered in isolation from Amnesty International's existing human rights policies and positions. All of Amnesty's positions, including those on gender equality, violence against women, non-discrimination, human trafficking, sexual and reproductive rights, access to justice, rights to and at work, and the right to adequate housing apply equally to sex workers as to any other individual facing human rights abuses. In fighting for the full realization of sex workers' rights, Amnesty International must both acknowledge and prioritize the issues raised in this document and mainstream the rights of sex workers into all relevant areas of work. This policy reflects a growing body of research from United Nations agencies, human rights organizations, and social science, which indicate that criminalization, in its varying forms, exposes sex workers to increase of human rights abuses. The policy is based on principles of harm reduction and the human rights principles of physical integrity and autonomy. This policy does not change Amnesty International's long-standing position that forced labor and human trafficking, including for the purposes of sexual exploitation, constitute serious human rights abuses and must be criminalized. So let's go ahead and just make that clear at the outset. This policy does not change long-standing principles that forced labor and trafficking are bad, and we should all work to end them. This policy is not about human trafficking. This policy is about consensual sex work. Getting that out of the way right away. Next sentence. Under international law, states have a range of obligations to prevent, suppress, and punish trafficking in persons, especially women and children. Next, Amnesty International considers children's involvement in commercial sex acts to be victims of a grave human rights abuse. Under international law, states must ensure that offering, delivering, or accepting a child for the purpose of sexual exploitation is covered under criminal or penal law and must take all appropriate measures to prevent the exploitation and abuse of children. Second big point, this policy has nothing to do with children engaged in sexual work. In fact, nothing at all. It is only about sex work involving consenting adults. So let's just put those other two issues off the table. They have nothing to do with this policy. States have a duty to ensure that sex workers from groups at risk of discrimination and marginalization enjoy full and equal protection under relevant international instruments, including, for example, those pertaining to the rights of indigenous peoples and ethnic, religious, and linguistic minorities. I'm going to talk a little bit now about the terminology Amnesty International uses in this, just so we're all using the same words. Sex worker and sex work. Amnesty uses these terms to include adults 18 years of age and above who receive money or goods in exchange for sexual services, either regularly or occasionally. Amnesty International recognizes that the terms used to refer to sex work and sex workers vary across contexts and by individual preference, and that not all people who sell sexual services identify as sex workers. Where possible, Amnesty International will employ the terminology used by rights holders themselves. However, generally, Amnesty International uses the terms sex work and sex worker. These terms are gender neutral, as people of all genders, including cis and transgender women and men, sell sexual services. As outlined above, the terms sex worker and sex worker are not applicable to children. Keep saying that to yourself. This policy does not apply to children. Sex work involves a contractual arrangement where sexual services are negotiated between consenting adults, with the terms of engagement agreed between the seller and the buyer of sexual services. By definition, sex work means that sex workers who are engaging in commercial sex have consented to do so. That is, they are choosing voluntarily to do so, making it distinct from trafficking. Sex work takes many forms and varies between and within countries and communities. Sex work may vary to the degree to which it is more or less formal or organized. This policy does not apply to dancing or to the production of sexually explicit material. This exclusion does not indicate that Amnesty International condones violence, coercion, or discrimination in these contexts. Rather, Amnesty International scrutinizes such conduct and expression in accordance with relevant international human rights principles and standards. In terms of criminalization, for the purposes of this policy, criminalization means measures that directly seek to punish sex workers through sanctions such as criminal prosecution, detention, and/or fines because of their involvement in sex work. It also refers to the indirect criminalization of sex workers through laws which, in prohibiting activities associated with sex work, such as buying sexual services or general organization of sex work, prescribe actions that sex workers take to manage their safety, and in doing so, violates sex workers' human rights, including the rights to security of person, to just and favorable conditions of work, and to health. Decriminalization of sex work does not mean the total absence of any regulation of sex work. Rather, it means that any regulation must be focused on respecting and protecting sex workers' human rights, for example, through requirements such as occupational health and safety standards. I'm going to talk a little bit now about intersectional discrimination and oppression. Amnesty International recognizes that intersectional discrimination and oppression have an impact on the lives of many sex workers and can play a role in an individual's decision to engage or remain in sex work and their experiences whilst in sex work. Systems of oppression such as gender discrimination, racism, socioeconomic inequality, and legacies of colonial occupation deny people power and lead to poverty and deprivation of opportunity. Groups most at risk of discrimination and oppression are frequently overrepresented in sex work. Women face entrenched gender discrimination and structural inequality in most societies and bear a disproportionate burden of poverty. They also make up a majority of sex workers globally. Transgender people and men who have sex with men also account for a significant proportion of sex workers in many states. People subject to discrimination on the basis of their ethnicity, caste, indigenous status, or who are migrants can also be commonly represented among individuals selling sexual services, as are people who live in situations of poverty. While systemic factors and personal circumstances related to poverty, discrimination, and gender inequality can have a bearing on some individuals' decision to do sex work, Amnesty International holds the position that such conditions do not inevitably render individuals incapable of exercising personal agency in these contexts. Approaches that categorize all sex work as inherently non-consensual actively disempower sex workers. that deny them personal agency and autonomy and place decision-making about their lives and capacity in the hands of the state. They also limit sex workers' ability to organize and to access protections which are available to others, including under labor laws or health and safety laws. Notably, human rights bodies, experts, and instruments increasingly reference individuals' capacity to consent to selling sex and critique criminalization of sex work as a human rights concern. Amnesty International considers that policies which aim to support and improve the situation of marginalized people must focus on empowering individuals and groups and not devalue their decisions, compromise their safety, and or criminalize the context in which they live their lives. Amnesty International recognizes and respects the agency of sex workers and their decisions to engage, remain in, or leave sex work. Globally, the voices of sex workers are frequently obscured or silenced as a result of the marginalization that they experience, including at the hands of civil society. Amnesty International will take a participatory approach to its work on sex work, ensuring that sex workers themselves help shape the movement's future efforts in this area. Entry into sex work. Sex workers are not a homogeneous group. People of different genders, ethnic, and socioeconomic backgrounds undertake sex work for a variety of reasons and report a diversity of experiences. For some, the decision to undertake sex work may be a reflection of limited options. For example, it may be one of a few sources of earnings open to a transgender person facing discrimination in employment. For some sex workers, the decision to sell sexual services is a matter of suitability or preference. It may offer flexibility and control over working hours or a higher rate of pay than other options. Other individuals may turn to sex work as a means of immediate survival because of extreme poverty or other forms of social exclusion. With regards to entry into sex work, states must do 4 things. 1. Adopt and implement effective programs, laws, and policies in line with obligations under international human rights law that ensure no person is coerced into sex work and provide effective remedies to people who have been coerced. 2. Provide appropriate support, employment, and educational options that actively empower marginalized individuals and groups, respect individual agency, and guarantee the realization of human rights. 3. Take all necessary measures to eradicate discrimination against marginalized individuals and groups who are commonly represented in sex work, including discrimination in employment. And 4. Develop relevant policies and programs in participation and consultation with sex workers, including those facing multiple forms of discrimination. In case you can't tell, the thumbs up are the parts of the policy I really, really like. So we're going to talk a little bit now about participation in sex work. Sex workers experience high rates of human rights violations globally. These abuses occur at the hands of a range of state and non-state actors, including law enforcement officials, clients, third parties involved in sex work, other private individuals, landlords, and healthcare providers. State responses to sex work and sex workers via criminalization and resulting stigmatization actively disempower sex workers and support a culture of impunity for human rights abuses against them. In terms of stigma and discrimination, sex work is generally a highly stigmatized activity, and sex workers routinely face prejudice and discrimination at the hands of state and non-state actors. Sex workers are frequently judged to have transgressed social norms of sexuality and gender, and can subsequently be portrayed as deserving of punishment, blame, and/or social exclusion. The criminalization of sex work in most countries places a criminal status on sex workers that can follow them in every aspect of their lives. This affirms and compounds a discriminatory view of sex workers as criminals, who in undertaking sex work invite harm, punishment, and judgment on themselves. Conversely, sex workers can also encounter stigmatization from those who purport to help them. The frequent stereotyping of all sex workers as victimized or as psychologically damaged individuals is harmful and disempowering to sex workers and unsupported by evidence. In many instances, the fact that sex workers are from communities that are already marginalized and oppressed compounds the prejudice that they face, meaning that they experience multiple intersecting forms of discrimination and often face the highest levels of judgment, blame, and criminalization. In addressing stigma and discrimination against sex workers, states must do 3 things. 1. Ensure that sex workers enjoy equal protection under the law and are protected from discrimination. 2. Take measures to eradicate stigma against sex workers. And 3. Ensure that sex workers are not denied access to health, housing, education, social security, and other services or government programs because of their occupational status. In terms of physical and sexual violence against sex workers, in many countries, sex workers face high levels of violence at the hands of both state and non-state actors. This violence is a manifestation of the stigma and discrimination directed towards sex workers. It also compounded by criminal laws that make sex workers the focus of punitive police responses and/or force sex workers to operate in covert ways that compromise their safety. In most countries, law enforcement is not adequately focused on the protection of sex workers from violence, but instead on prohibition of sex work through enforcement of criminal law. This creates an adversarial relationship between sex workers and law enforcement, which compromises the safety of sex workers and offers relative impunity to perpetrators of violence and abuse against sex workers. The fact that various aspects of sex work are treated as criminal conduct in many countries means that sex workers cannot rely on the support or protection of the police. For many sex workers, reporting crimes experienced during the course of their work means putting themselves at risk of punishment for sex work offenses and/or potential loss of their livelihood through related sanctions. This means that they frequently are unable to seek redress for crimes committed against them, thereby offering relative impunity to perpetrators. In addition to stigmatized and criminalized status that sex workers experience, this gives law enforcement officials scope to harass, extort, and perpetrate physical and sexual violence against them, also with impunity. Other laws that criminalize the buying of sex or general organizational aspects of sex work, such as brothel keeping or solicitation, often force sex workers to work in ways that compromise their safety. Bans on buying sex can leave sex workers having to take risks to protect their clients from detection by law enforcement, such as visiting locations determined only by their clients. Arbitrarily broad laws prohibiting organizational aspects of sex work often ban sex workers from working together, renting secure premises, or hiring security or other support staff, meaning that they face prosecution themselves if they try to operate in safety. In prohibiting activities that help keep sex workers safe, criminalization denies sex workers their right to security of person. In order to protect sex workers from violence, states must do two things. Sorry about that. Ensure that sex workers enjoy full and equal protection and effective remedies under laws on rape and sexual violence, including offenses involving abuse of authority, assault, trafficking in persons, and other forms of violence. 2. Introduce all necessary measures to ensure the effective investigation, prosecution, and punishment of violence against sex workers, including legal or procedural reforms where appropriate, such as standards of good practice for police. In terms of criminalization, in addition to the above concerns, evidence also indicates that criminalization interferes with and undermines sex workers' right to health services and information, in particular HIV prevention, testing and treatment, and serves as a contributing factor in the denial of access to justice and legal due process. It can also limit sex workers' ability to access housing, education, and social security schemes. The enforcement of criminal laws against sex workers can lead to forced evictions, arbitrary arrest, investigations, surveillance, prosecutions, and severe punishment of sex workers. Where sex workers face penalization when reporting crimes, their capacity to demand payment from or condom use with clients is also compromised. Notably, police routinely confiscate and or use condoms as evidence of sex work in a number of countries around the world. The criminalization of sex work also frequently works to exclude sex workers from protections available to others under labor and health and safety laws, and can impede or prohibit them from forming or joining trade unions to secure better working conditions and health and safety standards. This, in turn, can render sex workers at a greater risk of exploitation by third parties. In response to human rights violations caused by the criminalization of sex work, states must do 4 things. Repeal existing and or refrain from introducing laws that criminalize, directly or in practice, the consensual exchange of sex services for remuneration. 2. Limit prohibitions on the organizational aspects of sex work to those involving clearly defined acts of coercion, such as compelling a person to sell sex through abuse of authority. 3. Refrain from the discriminatory enforcement of other laws, not specific to sex work, such as those on vagrancy, public nuisance, and immigration, that in effect criminalize sex work or sex workers. And 4, ensure that sex workers are entitled to equal protection under the law and are not excluded from the application of labor, health, and safety, and other laws. In terms of the regulation of sex work, states have an obligation to ensure that all persons, including sex workers, are able to access just and favorable conditions of work and are protected against exploitation, including those who are self-employed or who make their living in informal settings. Amnesty International recognizes that some form of regulation will be necessary and that different contexts necessitate some flexibility of approach. Amnesty International does not take a position on the exact form such regulation should take, or whether it is necessary for such measures to extend beyond the general laws that broadly regulate other businesses or employment practices in a country. Rather, this should be determined based on the specific regulatory and human rights situation that vary between states. At a minimum, however, regulations should respect the agency of sex work and guarantee that all individuals who undertake sex work can do so in safe conditions, free from exploitation, and are able to stop engaging in sex work when and if they choose. Additionally, such restrictions must comply with international human rights law. In other words, they must be for a legitimate purpose, appropriate to meet that purpose, proportionate, and non-discriminatory. States should also ensure that participation and consultation of current sex workers, including those facing multiple forms of discrimination, in the development of any regulatory frameworks. In order to do these things, states must do 4 things. They must respect and protect the rights of sex workers to just and favorable conditions of work, just like any other laborer, including fair wages, safe and healthy conditions, and limits on work hours. They must utilize regulatory frameworks that comply with international laws and prioritize the safety of sex workers. They must ensure the participation and consultation of sex workers, including those facing multiple forms of discrimination, in the development of any regulatory frameworks. And they must recognize the rights of sex workers to form and/or join trade unions. And finally, the last section is on leaving sex work. In the same way that intersectional discrimination and oppression can limit employment options for people considering selling sex, it can also curtail individuals' ability to leave sex work when they want to. States have an obligation to ensure that no person continues to sell sex against their will, and that everyone can leave freely when and if they choose. In ensuring that individuals can leave sex work when and if they choose, states must do 4 things. 1, provide adequate and timely access to support through, for example, state benefits, education and training, or alternative employment. 2, develop and implement support programs in consultation with sex workers, including those facing multiple forms of discrimination, that are responsive to the lived experiences of sex workers and respect individual agency. 3, guarantee that sex workers are not compelled to participate in such programs, for example, through the threat of sanctions. And 4, take measures to remove common barriers to employment that sex workers face, such as issues relating to criminal records or employment history checks. And that, folks, that 20-minute conversation is the entirety of this policy. Basically, it's just ensuring that sex workers experience the same rights as each and every one of us, that they experience the same human rights, the same rights as laborers, the same just all rights as everyone else. So I'm going to put this video out there so that you guys can hear it. I'm going to post the policy so you can read it for yourselves. There's some findings after that kind of explain where the policy came from if you want to learn a little bit more. You can reach me on Twitter if you have any questions about what I've just said or my prior work with Amnesty or my work on this issue in general, although I would highly recommend you actually go talk to some sex workers and listen to what they have to say. But if you do want to talk to me on Twitter, you can reach me at Heather R_Parker. Yeah, I'm on there pretty much all the time, so I hope you found this informative. Any questions, come reach out to me, and please urge Amnesty International to support this policy. Sex work is work, sexuality rights are human rights, and sex workers' rights are human rights. Have a great night.